Okay, here's the next one in my little series. This one's on contract law offer and mistaken identity or mistake and related issues. Uh, this one has a lot of special interest to me. Again, this is not my case, but this is a case that's a real life case, and it was told to me by a client of mine, someone that I work with in Lexington, Kentucky. Some of you that know me or have paid attention, you know that I'm a University of Kentucky fan. I like to get to Lexington as much as I can, watch a basketball game, watch a football game, or just tool around the town. It's a great city, great college town, and one of the places that I really enjoy being. If I'm there and if it is season, there's a generally in October is when you have the racing season at my favorite racetrack in the world, Keeneland Racetrack. And Keeneland Racetrack is, gosh, it's just gorgeous. It's beautiful. It is just a wonderful, wonderful place. The men and women dress up. It's a social event. You see men wearing nice clothes, women with sundresses on when it's nice and pretty, and hats and things. And it's just a fantastic facility. It is a place where during the rest of the year, horses that are world class racehorses are stabled there. They're trained there. Sheiks, royalty, uber wealthy people from all over the world have their horses there, and their I think Secretariat is buried there, and just it's just a fantastic place. Some of you may know it even better than I do if you're in that industry or you've got that interest. So really, really interesting place. I like to go there. Now, how does it relate to what we're going to talk about today? What we're going to talk about is the meeting of the minds and contract law in general. Contracts are agreements. We've talked about this before. Contracts are agreements between parties, and part of an agreement is that the parties understand each other and there's a meeting of the minds. You understand you're going to do this or sell me that. I understand that I'm going to pay this or do this other thing. And so the parties are in agreement. I talked about how when I write a contract, I like to actually call it an agreement, so it kind of sets the tone right off the beginning. Well, what if this meeting of the minds didn't really occur? What if there was a problem because the parties didn't understand each other but thought they did? A mistake was made. And what happens if both parties are under the mistaken impression, or if just one party, if it's bilateral mistake or a unilateral mistake, and that makes a difference. Well, in this case, here's what we had. We had uh, a case, and again, we're dealing with thousands and thousands of dollars, where you had two horses and they had very similar names. They weren't identical, but they were pretty close. And I don't recall what the names were. It wasn't lightning and glue pot like I've used in some other example. It was something very very similar. Just one of those fluky kind of things that occurred. That one of them was Night Shadow, the other was Night's Shadow, or something silly like that. So one of the horses was world class, just incredible bloodlines, great pedigree, the kind of thing that you thought Triple Crown was coming for this horse. Great things on the horizon because they just had to be. The other horse was a good horse. It was again another race horse. It wouldn't be there if it wasn't. But it didn't have that kind of pedigree. And I don't know what the word would be called in horse racing, but I just say he was sort of a mutt, and mixed pedigree, and again, good horse, but the pedigree, the bloodlines affect the value of the horse, of the horse being sold, as you would imagine. So you had someone, it was a foreigner, in fact, that occurred in this situation, and he came in, saw the horse that was being sold, and saw the price and thought, gee, that's a good price. Now, it wasn't like, it was some fantastic, incredible price where the one with the pedigree, secretariat's, bloodlines or whatever, was would have been sold for $3 million, and this one was being sold for 13 cents. It wasn't anything that egregious, but it was a good deal, a really good deal, one that you would never get with respect to the one that had the better pedigree. But they consummated the sale. Now, here's the thing. It's not important to me for you to tell me whether that's a mutual mistake or if it's a unilateral mistake. You need to know that, gee, if it's a mutual mistake, either side could void the contract. It's voidable on either side. You need to know that if it's a unilateral mistake without other circumstances, that it's too bad, so sad, you've got to live with it, kind of guy. You need to understand those basic terms and the law itself. That part is critical. What is not critical is being able to tell me who wins in this case. Uh, you need to know kind of what the scenario is here. Um, the In this case, you'd look to things like, well, what did the buyer say when he was buying it? What did the buyer say? Oh my gosh, I never dreamed that I would be able to own a horse with the pedigree of Secretariat or with so and so as the mother or whatever, and those things not be accurate. If that's the case, then the seller knew or should have known that the buyer was operating under a mistake of fact. And even though it's a unilateral mistake, the buyer would be able to make the contract void through because it's voidable. Um, did the buyer not say anything? Just really appreciate the opportunity and looking forward to owning this horse. Depends. Did the seller um, say, here it is. I can't believe that you're buying this horse with no pedigree, but I'm awfully glad that you are. Something silly like that. They wouldn't say something like that. But again, you get where I'm going with that. What's important is for you to understand that the facts can sort of set the stage for determining whether this is a unilateral mistake or a unilateral mistake where the buyer, where the seller knew or should have known that it was a mistake, or if it's a mutual mistake on both sides. Did the seller know or have reason to know, basically, with that? So that's kind of the thing that's going to be very important for you is to figure these things out. The funny thing is, like I said here on the end, um, it looks like I did not share my screen with you, did I? Yeah, the funny thing is that what is important, and I'll play the little PowerPoint slide here at the end when I finish. I won't say anything, so you may not even need to look at it. But if you want to look at it, I'll show you my PowerPoint slide. But like I said here at the end, what's important is not that you get the answer, but have the analysis. The analysis is what I'm looking for. When I'm issue spotting, that's what I'm going to look for. And also make sure you're not including irrelevant stuff in there, because part of understanding law and being able to work with law is knowing what's important, what's not important, and being able to answer the questions that are presented and nothing else. You don't need, I call them vomited answers. I don't want vomited answers for anything, just spewing everything that you know or think that you know. That doesn't do you any good, doesn't do me any good. That's a wrong answer. Answer the questions, and that's it. Now, the final thing is you almost never see these things happen. You almost never see these, mistaken identity on sale, and you almost never see them happen. They're not relevant until they are. And they really do occur. I go years sometimes in my practice before I see some particular thing that I've taught here in class, and it doesn't come up. And then all of a sudden, bam, it comes up. As I said, just this year, just very, very recently, in another video, I talked about a contract with a $60,000 liquidated damages provision per day delay that would have wiped out the whole contract in 3 weeks. Ridiculous in that scenario to include that in the contract. So, unfortunately, as I said, my client knew enough to have me review the contract before he signed it. We highlighted a number of different things. We negotiated some things, and that's one of the things we negotiated out of there. Uh, I probably won't see that again for several more years. Who knows? Similar things like that. Okay, I'm going to shut up. You don't need to go back and look at any of this if you don't want to, but I'm going to go ahead and go back to the first part of the PowerPoint slide, so you can see there's not much to what's there. Um, there was the contract law for the mistake, related issues, key component. We talked about that. Meeting of the minds, talked about that. Unilateral, bilateral, talked about that. Real case scenario, kind of setting the stage for that with a Keeneland racetrack. What a wonderful racetrack that is. And the issue to sell the haste of the horse with a similar name, but the but was they weren't similar quality value horses based upon the things. So anyway, that's it, and we'll see you on the next video.